Good morning, ladies and gentlemen. Welcome to meeting number 2 of the Interim Joint Committee on Judiciary. Appreciate you all being here. Before we call the roll, does anybody have any guests they want to recognize? We're going to get to our first presenter here is a guest of Senate President Pro Tem Givens, and we'll hear from him in just a moment. I want to give everybody else a chance. Since nobody else does, I'll just introduce my guests, which are enjoying their time in the NICU in Evansville or Newburgh, Indiana still. Rhodes, Oliver, and Riley Westerfield. Triplets were born.
Where are they?
Born 2 weeks ago today on the 4th of July at 8:47, 48, and 49 p.m. on the 4th of July. Lots of fireworks in the Westerfield household 2 weeks ago. Amanda's there with him now, and I left from the Ronald McDonald House this morning, and I will return to the Ronald McDonald House this afternoon when we're done here. So glad to have a healthy mama and three healthy babies. All right. Would you please call the roll?
Senator Berg, Senator Carroll, Senator Deneen, Senator Neal, Senator Schickel, Senator Stivers, Senator Storm,
Here.
Senator Turner, Senator Wheeler, Representative Banta,
Present.
Representative Blanton,
Present.
Representative Bratcher,
Here.
Representative Bray, Representative Burke,
Here.
Representative Decker,
Present.
Representative Dietz,
Here.
Representative Doan, Representative Flannery, Representative Griffey,
Here.
Representative Herron,
Here.
Representative Kulkarni,
Present.
Representative Lewis, Representative Maddox,
Here.
Representative Mosier, Representative Nemus,
Here.
Representative Petrie,
Here.
Representative Rawlings, Representative Sharp, Representative Stevenson, Representative Wilson, Co-Chair Westerfield,
Here.
Co-Chair Elliott,
I'm here.
Thank you, sir. I'll entertain a motion to approve the minutes of the June 6th meeting. Motion made. Is there a second?
Second.
Second. Any questions, changes, edits anybody sees? Seeing none, all those in favor, please vote by saying aye. Aye. Those opposed? Minutes are approved. All right. Back in the session, Senator Givens, who's just down the hall for me through the door, encouraged me to stop by his office to meet a young man that is still a student at WKU. Still is. Thank you. Mr. Caleb Neitzel, and he had a really interesting presentation. I wanted to give him an audience with the Judiciary Committee since it's relevant to the practice of law, just a little bit. And so I want to welcome up Caleb Neitzel, who's a student researcher at Western Kentucky University, to talk about class action lawsuit advertising. Caleb, come on up. Members, you should have in your packets a little one-page summary, and it's also online for those that want to pull that up on the website. Caleb, you have the floor when you're ready, sir. Hit that button, and when you see a green light on, you're hot.
Okay, thank you.
There we go.
I want to say good morning and congratulations, Senator Westerfield, on your 3 children, on your triplets. That's awesome. But I also want to say thank you to you, Co-Chair Westerfield, for allowing me to speak here today. I would like to thank the committee for listening to what I have to say, and I would like to thank Senator Givens for his work in making this happen. Additionally, I would like to thank the Gatton Academy because they've provided me and lots of others with the opportunity to do this research and also with a lot of funding, and that's really been critical, and it's been a great experience. So like Senator Westerfield said, I am a current student at Western Kentucky University. I am a junior, and I am a business economics major. I do intend on attending law school, so that kind of shows the interest in law.
We'll see if we can break that habit for you real quick.
But anyway, I would like to start by saying, kind of before I get into things, that none of the funding for this project came from the pharmaceutical industry, the legal industry, or the healthcare industry. So that is something that I think needed to be clarified and gotten out of the way. All of the funding for this project has come from the research budgets from Western Kentucky University and Vanderbilt University. My research mentor, Dr. Jacob Bile, is an economics professor at Western Kentucky University, and he has a law degree from Vanderbilt. And we work very closely with Dr. Kip Viscusi, an economics professor there at Vanderbilt, and he was really instrumental in helping us to get a lot of this data and collect that, and also with the analysis. And so the funding from this came out of the research budgets from those two universities. But anyway, getting into it, throughout the last year, I have assisted my mentor, Dr. Jacob Bile, in conducting research regarding the regulation of class action lawsuit advertisements. Attorneys spend a total of about $1.4 billion every year on class action lawsuit advertising in an attempt to recruit more clients for their suits. While these advertisements can help to connect people who have suffered damages from an incident to a lawsuit which can compensate them accordingly, no federal law currently exists regulating the content of these advertisements, and only 8 states have passed such laws. Kentucky is not yet one of them. The largely unregulated nature of these advertisements has led to concern in recent years that when used in a misleading or unethical manner, that these advertisements could have serious negative ramifications. These ads often use over-exaggerated language, or even sometimes they will use government seals. So you'll see like an FDA seal or something on one of these ads. So like maybe it's an advertisement for a class action lawsuit against a pharmaceutical company. A lot of times you'll see an FDA seal on there to try to give it some sort of kind of credibility, and it appears almost as if the advertisement has been approved by the FDA when it hasn't. So we decided to focus on the regulation of these advertisements and more so the lawsuits relating to the healthcare and medical industries, because we felt that those had they had a higher chance of causing serious problems, causing injury or even death to people. Because the main concern with this is that if people see one of these advertisements, if someone's medical professional has prescribed them a certain medication, and they see one of these misleading advertisements for a class action lawsuit on TV or anywhere, that it could cause them to go against the medical advice of their doctor, and it could cause them to get seriously injured or could even result in their death. In 2019, the FDA actually identified 66 of such cases where people who had seen advertisements of class action lawsuits removed themselves from their medication. They stopped taking their medication, and they ended up either getting seriously injured or dying. And also in 2019, the FCC sent letters to 7 attorneys who they felt like were responsible for some of these misleading advertisements, and they sent these letters as a way to kind of chastise them, because there wasn't a lot of legal enforcement that they could take against them at this point. It's definitely like understandable that they would use serious rhetoric, and so that's not necessarily the point. But the idea is that they're over-exaggerating the potential complications and the chances of having complications with a lot of these drugs. Also, kind of piggybacking off of the whole using government seals, a lot of times they will include phrases such as public health announcement, health alert, things like that. It tries to add some sort of officiality to the ads. And so a lot of times people will see these and they'll think this is something that is being government sponsored or at least government supported or approved, and it grants a sense of credibility to the ads that maybe they should not have. So the purpose of our study basically was we were trying to see how watching these advertisements would affect people's risk beliefs relating to certain drugs. So the idea was we surveyed 1,292 participants, and we had those people, we prescribed them a fictional drug, and we gave them a list of potential side effects, and we had them watch an advertisement for this drug, which also listed the side effects. And then also they watched a doctor's testimony, their prescription. And so then we wanted to ask them how risky they thought taking the drug was. And we found that they typically did not see the drugs as that risky when only seeing the advertisements for the pharmaceuticals and seeing their doctor's recommendation of that. However, we then showed them a fictional advertisement for the same drug that models one of these advertisements for these class action lawsuits. And we found that after watching these ads, they typically seen the risk perception of taking this drug, it increased by 5.1%. So basically, on average, people thought that people had a 5.1% higher chance of thinking that they would experience serious complications as a result of taking the drug. And that doesn't really seem like a huge difference, 5.1%. However, we decided to look a little deeper into that. And of those over 1,200 people that we surveyed, approximately 25% of those people were elderly. And so we decided to really dig into that and see if that had any more of a difference. And when we did an R-squared test for the elderly population, we got an R-squared value of 2.2, meaning that we found a very significant link between watching the ad and a person believing that they were going to experience severe side effects from taking this drug. And so we found that the elderly population was very vulnerable to these advertisements because they often would kind of value that advertisement kind of not maybe on the same level as their doctor, but they would give it a lot of weight and a lot of credibility. And this was very different from kind of the overall population. So then, as we began to look into it, we also asked some questions towards the end of the survey of whether or not people thought that these advertisements should be regulated by the government. And we found that almost every demographic believed that the advertisements should be regulated by the government except for the elderly population, which was really weird. It was really interesting because the people that seemed the most vulnerable to the advertisements were also the people that were the most opposed to regulating the advertisements. But then we kind of took a step back and we were looking, and so we were thinking, well, if the idea of legislating this is to say, okay, well, we want to take credibility away from these advertisements, and we want people to rely more on their physicians' opinions rather than maybe that of an attorney, then is it possible that is maybe a beneficial thing if that legislation would cause the elderly population to have less confidence in the advertisements? And so that was just a really interesting thing to think about. And it would be an interesting thing to kind of see play out as far as legislation goes. But so as we kind of looked into it more, we decided to start kind of digging at other states that had passed legislation. So the first state to pass legislation regulating these advertisements was West Virginia. I think they passed that legislation about 10 years ago. But their law that they passed it prohibited the use of any government seals in attorney advertising, and it prohibited the use of phrases such as health alert, public service announcement, those types of phrases that are intended to give some sort of seal of approval from maybe a government authority. And so it banned all of those phrases in that, and it also banned a few other like forms of deceptive advertising. It banned like using like punchlines or nicknames or phrases that created an unrealistic expectation of results from the lawsuits. And another thing that it did was it banned law firms, the class action law firms, from selling the information or sharing the information of their clients with to other law firms without the client's permission. And the reason this was really important was because there were law firms that were acting essentially as only as advertising, basically. But they had to be legally be classified as law firms to be able to do this advertising. But they would advertise on behalf of other law firms, and then they would just pass the cases along, but without ever really having the cases for themselves. These law firms were never really trying their own cases. They were only existing so as to advertise for other law firms. And the West Virginia law banned that. And since I don't want to say a lot. Several states have followed suit, and most recently there would be Tennessee and Florida. I don't remember the exact year that Tennessee passed their law, but it was within the last 4 or 5 years. And Florida, they passed their law in 2023, so last year. It passed about the time that I was kind of starting to really work on this project. But they have followed the model of the West Virginia law, and even in Kentucky, we had a similar bill that I believe that it died in committee a few years ago. I don't know the specifics on that, but we did have a bill at one point that was similar to those bills that have been passed in Florida and in West Virginia and in Tennessee. But overall, these laws have kind of addressed some of the issues that we have found. So the West Virginia law, one of the big kind of challenges that you often get with these laws is First Amendment challenges. A lot of opposition will say that it restricts the right to free speech. But there was a lawsuit that came against that law, and it was in West Virginia. It was against the law in West Virginia, and the Fourth Circuit Court ruled that this was not a violation of the First Amendment, and I think the opinion was that it's no different than just false advertising laws, really, essentially. And so there's been several other states. I think there's 8 now that have passed laws, but there's been several other states that have passed that have introduced bills, and they often die in committee and hang up on that point. But anyway, I think that pretty much sums up the research that we've done. And again, I would like to give a big thanks to Chairman Westerfield for having me here, and Senator Givens, and of course the Gatton Academy and Western Kentucky University. Without those people and organizations, this really would not have been possible. And I'm really proud of the results that we've had, and I think that we've shown a lot. And the poster that's up there has kind of a brief synopsis of the research that we've done. It's just a very quick, fast version of what I said today, and it has some of my contact info on it. And so if anyone has any sort of questions or wants to reach out, I'm happy to do so, or I'm happy to answer questions now.
Thank you, Mr. Neitzel. We actually have a question from Representative Nemes.
Okay.
Mr. Neitzel up here.
Yep.
Western Kentucky graduate. Good to see you. You did a wonderful job.
Thank you.
I just see this a little bit differently than you. In a state that's been preyed upon by some of these organizations, including most especially the Sackler family that's killed thousands and thousands and thousands of Kentuckians, including some in my own family. I don't think we should make it harder to sue these people. I think we should make it much easier. So I wonder, I would agree with things like making sure they don't use the seals because we don't want there to be any misrepresentations. Mm-hmm. But if a drug company has done some things that have led to the death, I think that person, that organization, and the family, like the Sackler family, should be brought to justice and put in prison. I would also say just a comment that you said about a number of people who would die from this. I wonder how many deaths have happened at the hands of these kinds of places, of these kinds of organizations, and how many lives were saved because law firms who took the risk of these lawsuits have sued these very bad actors, hopefully into oblivion and hopefully in the prison. So while I respect your position, we don't need to make it harder to hold these companies accountable. We need to make it easier. Thank you, Mr. Chairman.
Can I?
You certainly can.
So, Representative, I'd like to say that I really do appreciate that comment and that stance, and I will say that I agree with you. I think anybody would agree that when malpractice has happened, I think that lawsuits need to happen as well, and I don't think that anybody would argue that that's not the case, and that's not really, I think, what this is about. That's not what these laws are about. I think, and it's not about making it harder to sue, but it's about trying to put regulations on this so that there's not bad actors the other way, because there have been. And so I agree with you that bad actors should be brought to justice, but I think that this is more about bringing people to justice both ways, not just on the pharmaceutical side. Although I agree with you that when those instances of malpractice has happened, that those people should be brought to justice.
I appreciate that. We've got 2 more questions. That's all I'm going to take so we can move on because we've got a healthy agenda. Senator Berg.
Thank you, sir. Very, very interesting presentation. Very, very much appreciate you taking the time to be here and share with us. And you can't do this for me, but I think we need to expound on this research and look at deceptive advertising practices across our state. I mean, I personally very familiar with deceptive advertising coming from Medicaid and Medicare Advantage programs that are literally pounding our airways and our phones with deception. They're lying to people. And these class action suits, a good start. So thank you. And I don't think this has anything to do with holding pharmaceutical companies accountable. We're in a different world. We're talking about the information that we allow to be fed to our constituents, knowing that it is deceptive. Thank you.
Representative Maddox, last question.
Thank you, Mr. Chairman, and sir, I appreciate your testimony as well. Without having any language, we'll just kind of set aside the concerns that I might have about the First Amendment. I'm sure that others on this panel would as well. But it's the underlying subtext for me, the concept that Kentuckians would somehow be too foolish to be able to decide for themselves and make good decisions as to whether or not they need to follow their physician's advice or whether they need to do more research or ask more questions, that, you know, a piece of mail is going to somehow cause them to not be able to make those good decisions, or that they don't have the ability to decide for themselves, you know, or to consult a physician further. I think that subtext is a little concerning. And I understand in terms of deceptive practices that you want to make sure that folks are not receiving inaccurate information, but I am fearful of anything that could create a dampening effect on a citizen's ability to have that information and make good decisions for themselves and their families. Thank you.
May I respond to that?
Briefly, yes, sir.
Okay. So I would like to say that, first of all, I agree with you that people should be able to make these decisions. However, I think that the idea is not it's if someone makes the decision to go off their medicine because of this, that's not saying that they are foolish. That's saying that they were presented with wrong information. And I don't think that there is kind of underpinning language here, because I think that when the Food and Drug Administration has identified instances where this has happened, I don't think that that's saying that those people are foolish. I think that that's saying that they were fed bad information. And that doesn't mean that we need to prevent people from being able to make these decisions for themselves, but that's saying we need to give them the correct information and as much information as possible.
Thank you, Mr. Neitzel, and well done. I appreciate it. Keep up the good work, young man. Do well. Everyone there at the Gatton Academy, you're the brightest and the best, and we're thankful for you. Looking forward to seeing what you do.
Thank you.
Thank you. All right. I want to welcome our guests digitally from our friends at CSG, Josh Weber and Nina Solomon. And while Robert is heading down there to turn that on, Representative Bratcher has a guest.
Thank you, Mr. Chairman. I've got a constituent or close to my district constituent. Stand up, Jamie, real quick. Jamie is now the Chief Executive Officer. I should clear my mouth before I start talking. Of CASA of the River Region. And I had lunch with her the other day, and she's got a lot of great ideas for our CASA programs here in Kentucky. She comes from Ohio, grew up in Louisiana, and let's make her welcome.
All right. Nina, are you all there?
I am. Can you hear me and see me?
Yes, ma'am. Good to see you. Glad to have you all zooming in this morning. You have the floor. And actually, before you start, members, copy of their presentation is in your folders. It's also, again, online, so you can follow along in whatever form and format you wish. All right, CSG team, whoever's leading off, you have the floor.
Great, thank you. And it's just me that you have here today, but thank you so much to the chairs of the committee and members for having us present to you all today. And congratulations, Senator Westerfield. I have one toddler boy, so 3 I just cannot even imagine.
Well, that makes 2 of us.
So wanted to share with you all some recent data and some recent work that we've been doing at the Council of State Governments Justice Center related to juvenile justice and youth justice and what's happening with youth and families around the country, as well as share some Kentucky-specific data with you all and some key questions that you may all want to consider going forward as you look to improve the youth justice system in Kentucky. So just a little bit of background in case folks are not as familiar with who we are. The Council of State Governments Justice Center, we're a national nonprofit, nonpartisan organization. We work with state policymakers around the country to provide them with research, data, strategic advice, and guidance on public safety issues, both in the juvenile and adult criminal justice systems. In our juvenile justice team, we explicitly focus on trying to improve public safety as well as improving outcomes for young people that interact with the juvenile justice system. And we do that in a couple different ways. One, we produce kind of policy briefs, research documents, synthesizing research and information on what actually works to improve outcomes for young people, reduce recidivism for young people involved in the juvenile justice system. And we use these seminal documents as we work with states and jurisdictions around the country. We also try to respond to emerging issues in the field, challenges that states and local jurisdictions are facing related to juvenile justice. So these are just some reports that we've released in the last several years around the staffing crisis, around the juvenile court, and trying to improve judicial work in the juvenile justice system, as well as a report around probation conditions for young people. We also work directly in states and counties around the country to help facilitate system improvement in their juvenile justice systems. You can see the array of different types of states that we've worked in over the last several years to help kind of assess where states are in alignment with the research and what we know works to improve outcomes for young people in the juvenile justice system. So I'm going to start the conversation today before we get into Kentucky kind of specific data, just to walk through some of the key challenges that we're seeing facing young people in juvenile justice systems around the country nationally, to ground our discussion before I get into more specific Kentucky data. So overall, not surprising to many of you, as a key framing note, we've seen a significant decline in the use of incarceration with young people, the number of youth referred to court, the number of youth arrested and detained. We've seen a significant decline, about 70% from 2000 to 2022. And we see that decline, and we'll show you that as well in Kentucky. When we look historically at national data in terms of the type of offenses that young people are committing that get them involved in the juvenile justice system, that has not changed very much over time. It hasn't changed, and you can see in this table the proportion of young people at each point in the juvenile justice continuum, at arrest, at referral, petition, and so forth, that the proportion of young people committing different types of offenses has not changed. This just shows the proportion of young people committing a non-person delinquent offense. And you can see that proportionally has not changed very much over time. 2021, 2022 data, and then 2005 data in parentheses below that. More recently, and I know concerns for you all in Kentucky as well, we've definitely heard concern around youth violence and youth gun violence in particular. And while youth gun violence remains historically low, a decline of about 54% from 2000 to 2022, it's still a long-standing problem and one that we know deserves further attention and more targeted attention. We've also seen a surge in some youth violence post-pandemic, as well as a surge in youth victimization. And what's important to note is that we know that many young people who are involved in violence have also been violently victimized themselves. And so it's really important to address kind of both sides of those issues. On this slide, we just show you some data points around the decline in youth violence overall, but to think about how do we think about this issue in a more nuanced way, because you can see at the third data point that there has been a 52% increase in terms of homicides, right? So when we look at particular offenses or arrests for weapons also increased by 44% pre-pandemic to post-pandemic. It's really important to take a look at your data in a more nuanced way, because while overall youth violence may have decreased, there are particular areas that deserve further attention and that warrant more interventions. In addition to concerns around youth violence around the country, states are facing increasing challenges in promoting youth well-being. We're seeing increases in youth hospitalization and in key health indicators that signal a national crisis in youth mental health and youth well-being. There's a staffing and retention crisis in juvenile justice across the board, not just in facilities, but also with community-based service providers and court systems, which is causing waiting lists for services, backlogs in cases, and at times unsafe conditions for both youth and staff in detention and long-term facilities. We've seen that in headlines around the country, and the staffing crisis has made things a lot more difficult for juvenile justice systems that are trying to implement research-based approaches and improve outcomes for young people and families. A year ago, we conducted a national survey, and this report is available on our website to look at the staffing challenge. And I won't go into detail here because we are limited in time. But unsurprisingly, our survey uncovered significant challenges and that most systems don't have a clear strategy to how to address these staffing issues. And again, this is not just in facility line staff, but juvenile justice supervision, community supervision agencies, as well as with community-based providers. And that's really damaging the capacity of these community-based providers to provide the needed services to young people and their families. And it's hindering their ability to coordinate with other organizations and with juvenile justice systems. When we look at national data, we're also seeing an increase in youth mental health challenges and the intensity of these mental health challenges, particularly post-pandemic. We know from the national data, there's been a dramatic rise in teen anxiety and loneliness and depression and suicidal ideation. And there's a real challenge with behavioral health systems that treat adolescents in most states and jurisdictions. We always, every state that we work in, there's significant gaps in community-based and residential behavioral health services. And increasingly, we see the juvenile justice system becoming the default service provider for these young people, even though that may not be the best avenue for these young people to get access to services. And we're seeing many states that are struggling to address these issues in a comprehensive, integrated, and research-based ways. These are very significant challenges that require very targeted approaches and require a lot of alignment when you're thinking about resources and capacity, but we're not necessarily seeing states thinking about these challenges in a more coordinated or comprehensive way. We've seen some states start to develop more innovative approaches to address some of these challenges that I mentioned. Here are just some headlines from states like Kansas, which has expanded their national Stepping Up or their statewide Stepping Up initiative to also include juveniles to address mental health issues at the front end of the juvenile justice system. We've seen states try to establish children's cabinet to coordinate the continuum of services for young people, both prevention and intervention. We've seen states establish offices of violence prevention and intervention, but there's still a lot of opportunities here for states to think creatively and coordinate across state agencies and across systems to think about these challenges. I know we left this presentation kind of as a leave behind. You all have received it, so I won't go into too much detail, but here are just some other examples of how states have addressed some of these crises or challenges by developing early intervention systems, expanding youth mobile crisis, developing assessment centers, and trying to divert more young people from the juvenile justice system and treat them at the front end of the system. And in terms of looking at violence prevention, while it's important to think about that most kids are not committing these violent offenses in the juvenile justice system, it's still really important to develop a very targeted and broad violence prevention and intervention array of services or plan that is based and grounded in research and in best practices, creating more intensive community-based therapy options, treatment options, and wraparound case management, using credible messengers, mentoring, violence interrupter. There's a lot of models out there for how to develop these broader violence intervention plans, and we can provide more information on that as well if folks are interested. So that was a little bit about the national context, and I want to share some data now that we analyzed as part of a national report that we released last month about Kentucky's juvenile justice system and what trends we are seeing in Kentucky. So similar to what we're seeing nationally, behavioral health issues are still a significant driver of juvenile justice involvement, both nationally and in Kentucky. You can see here on this slide, it shows the proportion of high school students in Kentucky that have reported a mental health challenge in 2021. You can see here in all three categories how these needs are even greater for female students than they are for males. The first column, the percentage of high school students that felt sad or hopeless for 2 or more weeks. The second, where mental health was most of the time or always not good. And the third, seriously considered or attempted suicide. About similar to the national average, but relatively high, particularly for the female population. Building on that a little bit further, we see students in Kentucky, again, and nationally, reporting various ways that they are experiencing trauma. And particular attention here to the middle box, 23% of Kentucky high school students reported ever seeing someone get physically attacked, beaten, stabbed, or shot in their neighborhood. And this really goes to the point around trauma and the number of young people that are seeing trauma or experiencing trauma in their daily lives and the impact that can have on their future involvement in the juvenile justice system. And so what are the trends for the juvenile justice system in Kentucky? How is the system responding to the needs of these young people, particularly young people with behavioral health issues, as that has increased over time? So first, the arrest rate in Kentucky for young people has decreased significantly, 62% lower in 2020 than 2010, and 30% lower than the national average. And this is a testament to the great work that folks in Kentucky across the board have done over the last several years to reform the front end of the juvenile justice system, keep kids out of the juvenile justice system that don't need to be there, especially since the passage of that reform bill about a decade ago. In terms of who is getting arrested still in Kentucky, and again, overall arrests have declined significantly since 2010. More than there is we don't have, I just want to mention here, we don't have more than 2020 information. We don't have 2022 information. We have seen in other states where we did have data in 2022, there was a slight uptick in arrests post-pandemic. And so we can expect to have seen that in Kentucky as well. But I just want to note that we didn't have 2022 data for Kentucky here. We can see the proportion of arrests, though, on this slide over the years for person offenses, non-person offenses, and violent offenses. And we see that for person offenses, the proportion of arrests for person offenses has increased very, very slightly, a few percentage points over the years. But it's really important to see that still in 2020, about 70% of all arrests for young people were for non-person offenses. So 70% non-person, 20% person, and 9% violent. And violent here are what the FBI considers violent crime index crime. So that's rape, homicide, robbery, and aggravated assault. The arrest rate for violent crimes in Kentucky decreased as well, 23% since 2010. In 2022, 313 youth were arrested for those violent index crimes that I just mentioned. And the arrest rate for violent crimes in Kentucky was 39% lower than the national average. In looking at pre-adjudication detention rates, so detention for young people before they are adjudicated of an offense, the detention rate in 2021 in Kentucky is 41 per 100,000 young people, which is 21% lower than in 2011. However, and this is where we still see some of the challenges in Kentucky, probably not surprising to most of you, is that the pre-adjudication detention rate in Kentucky was 28% higher than the national rate in 2021, showing that Kentucky is using detention more than other states around the country. In looking at who is detained pre-adjudication, 30% of youth were held in 2021 for status offenses, non-person offenses, or technical violations. We did see the proportion of youth that are being detained for person offenses has increased over time. So that does show that the kids are slightly more serious over time that are being detained. But again, 30% still being detained for status non-person or violations. And one question to think about in looking at this data and trying to dig in a little bit deeper is looking at alternatives to detention at the local level in the community. Are youth being detained for non-public safety reasons? Are youth being detained because these alternatives don't exist? So just some questions to think about in looking at detention rates in Kentucky. In terms of commitment to DJJ custody, the rate in Kentucky has decreased as well, 81% since 2011, 47% lower than the national rate in 2021. However, while the number of kids in commitment is at its lowest point in time, you can really see here, it's very stark, the number of kids that are committed compared to what the numbers look like in 2011 or 2013. 62% of committed youth in 2021 were placed due to status, non-person offenses, or technical violations. And this is higher than the national average. Across the country in 2021, 54% were placed for those different offenses compared again to 62% in Kentucky. I want to spend a moment on this because I know there's a lot of news, a lot of attention right now on the deep end of the system in Kentucky. And we did do an assessment just to remind folks, and I can share more information. We have a whole presentation on this that I won't go into here because of time. But in 2019, the Justice Center did assess DJJ facilities through our work in the National Reentry Resource Center. It focused in particular on the provision of research-based services to young people that were in custody, and we provided the state with recommendations. And here are some of the key findings. Again, this is a very long presentation that we delivered to the state back in 2019. But given the continued challenges that DJJ and the state is facing around the deep end of the juvenile justice system, it would be worth taking a look back at that presentation and at those recommendations and findings to see whether some of the challenges that were uncovered then, if they were addressed, how those recommendations were implemented, and what could still be useful now, given, again, the attention that is being placed on the deep end of the system and the challenges that you all are looking at. And just wanted to end that section around Kentucky's data with some questions for you all to consider as you're thinking about how to improve outcomes for young people, how to improve the youth justice system in Kentucky, and in particular, how to address the more complex, more complicated behavioral health needs that young people are facing as they're coming into contact with the system. So thinking about what are the greatest challenges to get to improving public safety, to improving youth outcomes? What are the shared priorities? Are young people receiving the right level, type, and quality of supervision and services? How are you using screening and assessment tools to make sure that that's happening? How can the state improve the delivery of community-based adolescent services to further prevent young people from becoming involved in the juvenile justice system and to better meet their complex needs? And how can youth family service systems, providers, communities, policymakers, state agencies work together to address all of the common challenges that Kentucky and as I mentioned, states around the country are facing around the staffing crisis, youth violence issues, the capacity of service providers, the coordination of funding and being able to better leverage limited resources. Just some questions for you all to consider going forward. And lastly, the impetus, I think, for this presentation was that we recently released some tools and reports around juvenile justice and improving youth outcomes. And we can forward that if folks haven't seen it. We published analyses on our website looking at the most recent national data trends on mental health, arrest, violence, court involvement, and so forth. And that's where a lot of this Kentucky data came from. We're going to have a webinar on that data analysis later this month. We also released a report on young people who commit status offenses and younger kids who commit delinquents offenses. We did a 50-state scan to see how states are addressing those young people and provided recommendations on how to develop more effective responses to the needs of those young people. And lastly, we released a study looking at data in Texas around how diverting young people from probation could improve the efficiency and outcomes of the juvenile justice system. And lastly, wanted to let you all know that going forward, as a result of these tools and reports that we just developed and published, we are engaging in one-day site visits in select groups of states where we share more information, more in depth around national research, data trends, what the research shows works around interventions and innovations to address youth violence, address service delivery for young people with behavioral health issues, to identify what are some shared perceptions of where the juvenile justice system is in a state, what are the opportunities for improvement by conducting listening sessions with stakeholders, and then reflecting all of that back to state leaders around what the shared priorities are from stakeholders, what are some potential next steps, what are recommendations for short and long-term policy and practice change. So this is an option. This is something we're going to be doing throughout the fall. And obviously, if Kentucky is interested, would love to have further conversations. So with that, I'll stop sharing my screen and thank you all for the time.
Dana, thank you so much for that. I appreciate the presentation, and I'll make sure that 2019 presentation also gets distributed again to members of the committee. We do have a couple of questions. Members, if you can be concise. Representative Kulkarni.
Thank you, Mr. Chair. I just have one quick question. Going back to, I think it was slides 11 and 12 of the presentation where you were discussing the impact of staffing challenges. I wanted to know if, Ms. Solomon, if you had maybe the top 3 to 5 reasons or just the top few reasons why there are so many retention challenges?
Yeah, I mean, I think there's a lot of reasons and probably new reasons in our kind of new post-COVID world around how younger people are experiencing the workforce and what they're looking for in a career. I think people often turn to pay. I think that's one reason. I think the professionalization of this workforce is another thing that people are looking at. How do we improve training, what it means to work in the juvenile justice system, really ensuring that we're treating these individuals as professionals, certifications and training and so forth. Obviously, I think in terms of facilities, safety has been an issue. I know that there's a lot of incidents happening in these facilities that are creating unsafe conditions for both staff and for young people, and that might lead people to not want to stay. And I think the competition, we've seen states where folks that have been working in the juvenile justice system, for example, providing behavioral health treatment or interventions, now move to other systems to provide those same sorts of interventions or treatments because of better working conditions, better pay, et cetera. So I think there's a lot of competing reasons. In our publication where we looked at provided the data around the national survey, we also include recommendations, kind of both short and long term, for how to address the staffing crisis. So I'm happy to share those resources as well.
Thank you.
Senator Berg.
Thank you, Mr. Chairman. Thank you, ma'am, for a very interesting presentation. I know it's early, so we don't have all this data yet, but can you expound on any post-COVID trends that we're seeing? Because, I read that the number of youth homicides being committed by people under 18 is down post-COVID. Are our juvenile detention rates going back up? Where are we in the 22, 23, 24 world that you're not able to present to us yet?
We have that nationally. I don't have all of that data for Kentucky, and there's various reasons for that I won't go into in terms of what the data sources are. Nationally, in 2022, youth arrests for aggravated assault, rape, and robbery remained at historic lows when we compare that to almost any other time in the last, multiple decades. We did see in 2022 that there was an increase from 2019 prior to COVID in the number of youth that were arrested for homicide. We also saw an increase between 2019 and 2022, an increase in arrests for weapons for young people. So while kind of overall, the numbers are still really low compared to where they were 20, 25 years ago, there has been an increase pre to post COVID in homicides and weapons. That's national data. In terms of Kentucky, what I can show you is that the arrest rate for violent crimes was lower in 2022 than, a decade ago, but there was an increase between 2020 and 2022 in the arrests for violent crimes. So I don't want to discount that there is a concern and that there should be a targeted response to that. But in the broader sense of who's getting arrested, it's still a small number compared to all the kids that are getting involved in the juvenile justice system, where we still see 70% for non-person offenses. So there's kind of two big picture takeaways, I think, to note.
Thank you. Representative Doan.
Thank you, Chairman. I have a perception that young men are probably causing the majority of status offenses or being involved in this system more. You presented a slide titled "Behavioral Health Needs Are a Significant Driver of Juvenile Justice Involvement Have Been Increasing Nationally in Kentucky." On that slide, there's 3 charts, and in each one, the behavioral health needs for women seem to be significantly higher than for young men. Are we seeing a proportional increase based on that in offenses related to young women as opposed to young men? And if so, how are facilities changing or moving towards addressing young women, particularly with respect to housing, as opposed to young men?
Thank you. That's a great question. For this data, we weren't able to, and most often you're not able to unless you're working specifically with case level data from a particular system, disaggregate by gender or other categories. What we typically see in states is that the offenses committed by females versus males is different. You know, males tend to commit more of the serious offenses proportionally than females. We do see females experiencing more of these behavioral health issues, more trauma, more abuse, et cetera, getting them involved in juvenile justice, but they're typically committing non-person offense type of behaviors. We see females committing more status offenses. So those are offenses that if they were committed by adults would not be crime, like runaway or truancy or curfew. Those kinds of violations are typically committed more by females than by males. But it does beg the question, and I think to dig deeper into your own data to look at what that disaggregation looks like and how the juvenile justice system, not just in detention or in deeper end facilities, but on probation and on diversion, are there gender responsive programming? How are you addressing the different needs that females and males might have, and particular attention to the trauma and behavioral health?
Representative Herron.
Thank you, Mr. Chair, and thank you for your presentation. I actually have a lot to say, but for time's sake, I won't get into all of it. I think that the information that has been provided for us today was very helpful. I do wish that we had some of this information earlier in the year as we were passing policy earlier this session. I do have a question in particular regarding slide number 27. On that slide, it talks about that 62% of those committed youth are the status, non-person, and technical violations. What have you seen across the nation, some solutions to the technical violations of what people are doing to ensure that that population of folks aren't going back or being detained based on not a new offense, but something technical?
Great question. Thank you for that. So a couple things. I mean, kind of different ends of the spectrum, right? We've seen states where they put in statute, they pass laws that say kids committing certain offenses cannot be detained or incarcerated, and that could include technical violations. So we have seen states explicitly put that into their laws. But another option we've seen states do, or kind of both, is that they have created graduated response matrices, right? So that it helps supervision officers address technical violations in a more graduated and nuanced way, so that the first response is not putting kids in detention, is not incarcerating a young person or putting them before the court, but there's other options that they have available to address those behaviors before that kid is returned to court or placed in detention or incarceration. And so there's a lot of examples of states, and I'm not sure if DOJ has one, to be honest, have created these graduated matrices, and I'm happy to share some of those examples if that's of interest.
Mr. Chair, just one follow-up, if I may.
Very quickly, yes, ma'am.
Yes, I thank you for that information, and I hope that we as a body take you up on coming through and doing a one-day site visit. I think that based on some of this information that we've received and some of the policies that we've recently passed, it is going to be important for us to work very intentionally as I believe, and I hope that I'm wrong, that we're going to see an increase in our detention. And we know that right now our system is hurting. And so I look forward to working with my colleagues to continue to figure out some solutions for our system. Thank you.
Senator Neal.
Thank you, Mr. Chairman, and thank you for the presentation. I may have missed this. I want to Did you or have you reviewed, or maybe you've already testified to, but if you haven't, the long-term indications or indicators of crime, particularly what happens after a spike? I'm assuming there are spikes at different points along the way, but I'm interested in the long-term effect, whether that levels out, whether it comes back. Is that an indication of necessarily of future problems? Could you opine on that?
Sure, thank you for that. So we haven't. There's a lot of studies out there that we can point to around like long-term crime trends and what that looks like, and what we can project into the future. I will say that's why it's important to really look long-term and not just 1, 2, 3-year trends, because that could just indicate a blip and things could go back down. Which is why even looking at pre to post pandemic, I mean, we're only talking about a couple years. We're seeing a little bit of a spike in youth violence, in particular violent offenses. And it's really important to look at that and target that. But it's also important to look at it across a long-term trajectory. And that's why if you're looking back to 2010 and before that, it's still at a historic low when you're looking back at 2010, 2011, 2015 data. So we want to continue to look at the data going forward to see if the last couple of years spike is a long-term trend, or is it just a short blip kind of going back to pre-pandemic levels. So, but we can share more research. We don't do that at the Justice Center looking at crime trends, but know of other organizations that have looked at that.
Thank you very much. Appreciate it.
All right, for our last question for time here, Representative Moser.
Thank you, Mr. Chairman. And I want to thank you, Nina, for your presentation here. This is very interesting and certainly something that we've talked about a great deal. We've talked about prevention and some of the upstream programming, and we can certainly, there's a lot to drill into in this presentation and some of the initiatives that we have not really implemented that we know were recommendations. And Mr. Chairman, it seems to me that we could have an update from juvenile justice just about every year to try to see where we are, because we have made some attempts to implement some of these programs, and I'm not sure that they are actually being implemented. And so I think we need to look into things like better training and mobile crisis response, early assessment, SBIRT, that sort of thing upon intake, and really see what it is that the kids need. And my question was going to be, to what do you attribute the spike in violent crimes? But it sounds like you don't have that information. Is that correct, or do you have any thoughts about that?
Yeah, I mean, maybe I have thoughts. Thank you for that question. But don't have actual data on why. I think that's a great question. As you're having conversations with different stakeholders and different jurisdictions around the state, what they feel is contributing to that rise. I mean, I think the behavioral health challenges post-COVID, obviously school attendance issues post-COVID. I think there's a lot of things that could be contributing to that. But I think it warrants kind of a bigger conversation with different stakeholders. I think probably you'd find the reasons for that are somewhat similar, but there might be nuanced differences depending on the locality.
Members, thank you. Nina, thank you again so much. And I appreciate the hard work of the CSG Justice Center, not just for Kentucky, but around the country. We're thankful for the resources that CSG and your sister organizations provide to all 7,500 legislators around the country. So thank you very much.
Thank you.
All right. Vine, want to welcome up, actually, I think for the very first time as circuit judge, our friend, no stranger to the committee, His Honorable Chris Coron, circuit judge from Warren County, the 8th Judicial Circuit, and Director Comstock with AOC. I'm going to have you all come on up, but obviously everybody else, folks from APRIS, Allie and Jared, and folks from DOC, as questions come up, please feel free to just come on up here and join the stand or the witness table and answer the questions. There was a story in the press a few weeks ago about Vine, just an update on the system. We've had testimony before, Director Comstock, and you were kind enough to come before the committee last fall and talk to us about it. I just want to get an update on where things are. I don't so much care who's providing the service, but I think everybody on this committee wants victims to be able to be notified about what's going on with the case. As an attorney who has entered an appearance in exactly 2 criminal cases as an attorney for a victim, it'd be handy for me. But at least I'm tracking those cases and paying attention to CourtNet and communicating with my client, the victim, on a regular basis. Most of them don't have somebody like that. So tell us where things are today.
Well, thank you, Chairman. Hi, I'm Katie Comstock. I'm Director of the Administrative Office of the Courts. Appearing before the Judiciary Committee is always an honor, and I want to thank you all for bringing the issue of automated court notifications for victims to everyone's attention, and in particular for giving me the opportunity to discuss it from the perspective of the judicial branch. Your support is always appreciated. I'm going to go over briefly the background from last September, because I think I messed up some things in my testimony from last September. So I'm going to do a brief background from there and then tell you where we've gone since then. For over 14 years, we provided victim and court event data at the request of the Department of Corrections to facilitate their contract between them and their vendor, APRIS. The purpose of which was to expand Vine to provide victims with automated notifications via phone and email when there was an update in their offender's case, including a scheduled court appearance. We never charged DOC or APRIS for the ongoing provision of the court-related data. In fact, DOC and APRIS actually used grant money to pay us for our work in developing the data share algorithm, which we were appreciative of. Around 2021, when APRIS redesigned their platform to require access to all case data for certain offenses rather than before it had been just specific victim and case event data, around that time they were also bought by the data broker Equifax. We began to have concerns about the potential monetization and protection of our court data. Despite these concerns, we worked with APRIS to add language to our data share agreement to require them, after performing a search, to delete court record data. However, we later learned this wasn't happening, and at that point, that's when, in 2021, we stopped sharing the court data with APRIS. I will say the conversations we had with the committee last year really helped us bring us back to the table to address our concerns about court data and how they should be handled. I greatly appreciate the committee's help in facilitating those conversations, and I appreciate APRIS's willingness to meet with us. The renewed talks with APRIS have allowed us to work through our data concerns. Very appreciative of that, and have solidified the protection of the data as the cornerstone for any agreement moving forward. While APRIS has proposed a solution that addressed those data concerns, they now want us to finance the cost of the notification platform to the tune of $500,000 for a one-time implementation fee and $360,000 for a service fee for the first 12 months, with annual service fees increasing after that. That proposed cost far exceeds any cost we currently undertake for comparable services. Until 2021, victim notifications for court events were always a function of DOC's contract with APRIS. We've never had a contract for the provision of Vine court notifications. We simply provided the data necessary, just the data share. Unlike DOC, we don't have the funds appropriated in our base budget to pay for this service. So after talking with APRIS and learning of the proposed costs, we started looking for other solutions. That included looking at reconfiguring our existing text notification system to provide automated court notifications for victims. With this option, it would be an additional expense not appropriate in our base budget, but it would reflect a more, in our opinion, prudent and cost-effective use of taxpayer dollars by utilizing the existing texting application that we have within the courts. However, to do that, we must collect victims' contact information for this option to be feasible. Currently, we don't have victim emails and phone numbers to send them notifications. And collecting victim information hasn't thus far been a function of the court system. As we met with APRIS and researched using our existing text notification system, the General Assembly appropriated funds to the Unified Prosecutorial System for a case management system. When we first met, the prosecutors had yet to issue their RFP for the new system. So much has evolved since our last discussion. The language in the prosecutor's RFP states that text notifications for prosecutors and victim advocates to communicate about appointments and court dates are a non-negotiable requirement for the new system. So the prosecutor's new system it's undoubtedly an option for providing court notification to victims. We already share many data points with prosecutors and can enter into an agreement with them to directly provide upcoming court event data, very similar to what we'd previously done with APRIS. Additionally, our conversations with many prosecutors across the state indicate the victim notifications required under KRS 421-500 are not always straightforward. Often a victim's message may need to be modified to address a particular communication issue, concern, or sensitivity, and the courts wouldn't have that ability to vary the delivery or content in those notifications. And so I'm going to turn over to Judge Coron, who I know is no stranger to the committee in his former role as prosecutor and now as a judge, to kind of share his experiences.
Thank you. Chairman, thank you for the opportunity to appear. It's always an honor to come before the Joint Judiciary. When Katie and I were talking about it, Director Comstock and I were talking about it, and the issues that had arisen, it did bring me back to when we were dealing with Marcy's Law and the implementation of it. And I can tell you both, as a former prosecutor, I served as the legislative director for about 15 years and have gone through a lot of the issues we're dealing with. This is something I really think that we do not need to reinvent the wheel on. When I did learn about the RFP with the new PAC case management system, not only did that cure an issue that I believe that will be dealt with, I did hearken back to it does need to be a good reminder. The prosecutors and law enforcement are at the forefront in dealing with victims' issues and should be. If you look at going back to 1986, the implementation of the Crime Victims Bill of Rights all the way through Marcy's Law, it is incumbent on the prosecutors to be at the forefront of victim notification and our law enforcement officers. Katie and I were talking about the other day in a story. Every case is different. The needs of victim are different on every case. Perfect example that I wanted the committee to be aware, and this is why I think the management of victim notification and information and how that's handled is so paramount to make sure that we are doing it appropriately. I had a case a few years ago, a horrific rape case where a young lady that was a freshman at Western Kentucky University made the mistake, let somebody in her apartment under the guise of a neighbor that wanted to borrow something. As she explained to me, she heard the door click and lock behind her. She was subject to a brutal rape at that point in time. Thankfully, the offender was charged very quickly and brought to justice. But I remember the detective and the victim advocate for the Bowling Green Police Department meeting with her early on. Not only did she not want to be notified of any court date, she wanted to make sure she never knew her offender's name. And I remember when they brought that to me, I go, why does she not want to know her offender's name? For the rest of her life, when she heard that name, she did not want to have a visceral reaction to it. So that's just one of many examples we're dealing with, not only in the court system, but from the unified prosecutorial system. So when the RFP came out for this notification, I think having the prosecutors manage that through that, and obviously with the requirements of Marcy's Law, I think we have a solution going forward. Now, I can tell you now, in my position as a sitting circuit judge, one thing that most circuit judges I know, and most judges I do know, are very cognizant of, is we are proceeding through the court system. We are very aware, those of us obviously with a lot more experience in this system than others, how sensitive some of these victim cases can be. And it is not unusual for me during a criminal docket to inquire of the Commonwealth, has the victim been notified of this hearing? Is the victim aware of the resolution in this case? We're wanting to make sure, I see the court system is the kind of the safeguard to ensure as a second level of protection when we have issues that may arise with notification issues that come through the prosecutorial system and law enforcement. So I'll be happy to answer any questions in regards to that, but I do think we do have a system out there. I can assure you in talking, when Director Comstock and I were talking about it, I can assure you that I will be happy to coordinate the cooperation between the unified prosecutorial system and the court system with data share, because it's something that not only is necessary, but it's something that will be mandatory to make sure victims are being served appropriately.
Thank you both. Anyone have any question? Yes, Representative Herron, and then
Thank you. And I may have missed the beginning of this, so I may have missed this. Currently, are victims being notified right now, or are they not being notified because of the issues between the two?
The prosecutors are doing the notification for any victims. The automatic that we were talking about for the Vine hasn't been active since 2021. And so really the prosecutors are the ones that have been leading with those notifications.
To be clear, Director, you mean their victims advocates or the prosecutors themselves are making phone calls, sending emails, sending letters. They're not out for everyone that's not in
it's
that
not
space.
an automated.
We're not talking about automated texting or notifications or alerts. I
also want to clarify that this is just in regards to Vine Court. Very separate than the entire other.
Yeah, if you don't mind, turn your mic on and say who you are.
I'm sorry, I'm Beth Moore with the Department of Corrections, Staff Assistant and Legislative Liaison.
Yes, ma'am.
So we do have three different components, and we just wanted to be clear for everyone in the room that this is only on their portion of it. We still have our two portions, and I'd be happy to go over those if there's any questions.
So apologies, I should have made that clear
you're
from
fine.
the beginning.
And
I
we'll
didn't
ask
mean
you to do that in
interrupt.
just a second.
Okay.
But I just wanted to make sure, in response to Representative Herron's question, that everyone understood that when you say that they're handling the notification, that's not an automated thing. That's human beings in those prosecutors' offices that are reaching out to victims.
As of right now.
We hope.
Correct.
I can vouch for at least one office whose prosecutor's no longer there that didn't.
Sure.
But most of them are doing the right thing. So, Representative Herron, go ahead. I'll let you finish responding to that question.
Yeah, that is just a little concerning for me that I feel like that those folks could be helping victims in other ways. So I hope that we are able to get to a solution. As a case manager, calling folks on a regular basis can get tedious. And so if there is a way that we can expedite making sure that there's some type of automated system, we are very far along technology-wise, and I just think that if we're using folks, our victim advocates, I feel like that they could be helping those victims in other ways than saying this court date is such and such.
I couldn't agree more, and I think that's why it's so important that we don't, as we do so many times in government, which is never a good thing, trying to apply a one-size-fits-all approach to every event. We can't do that with this. We've got to make sure that victims are treated on a case-by-case basis appropriately, and the needs that they need are being served on that case.
Representative Doan.
Director Comstock, you had mentioned in your testimony that there was some friction in around 2021 where the third party that was administering the system wasn't necessarily purging data that they had agreed to do. Can you elaborate a little bit more on why that's there? I would assume these are public records. You know, if you're a victim, you testify in court, it's public. Was the third party categorizing that or using that and selling that data off? Or?
We have no evidence that was happening, so I want to say that. No, it was Kentucky is unique. It's one of the court systems that our court data is not readily accessible outside. We're very protective of it because really when people are coming to the court system, sometimes it's not freely. We have a lot of information on people, and especially in the society as data becomes monetized and so much, I mean, we all know we have profiles out there of us. So for example, like I know North Carolina, anybody, any organization can look up anything on anyone. That is not how it is with us. I will say with victims right now, they can go on our website. Anyone can check for individual court cases to see when things are going and when those dates are, but there's not there's not like a data dump which someone then has. For example, when people do criminal background checks, what ends up happening now is they will come into a clerk's office and they manually have to pull those case files. There isn't something where in other states they can have a big data dump of that court data. So we have no evidence that's what we're doing. But again, we're very protective and we're proactive with our data. And
you should be commended for it.
And for all of these reasons. So so I don't want to give the impression that was happening. It just, the protections we built in, we learned weren't exactly progressing as we had written them. And at that point, that's when the data share stopped.
Can I follow up real quick?
Very quickly, yes, sir.
And that may have just been me mishearing your testimony at the beginning, because I know that if I send an open records request in for a police report, that data is not a public record, but otherwise. So thank you.
I'm going to ask if you three would sit down for just a second. I'm going to have Apris come up here, and Beth, just be nearby. Okay. I appreciate it. Want to welcome Ali Mock and is Jared? Yeah. And Jared here, both with Apris, to hear from them about how things are going. While you're getting settled, let me commend you, tickled pink, to hear that the data, one of the biggest concerns, apart from making sure that the service is provided to victims, which is my first priority. I was very, very concerned about the data because, as Director Comstock just said, and as I've talked about before and others have said, it's really rich information and personal information, and it's valuable to a lot of companies, good and bad, and I don't like them having that unless we individually care to share it. And so I'm thrilled to hear that you all, through your conversations that I believe you've had since last fall, numerous conversations I've been told that you've had, you guys have worked that part out, and that's a big, huge hurdle behind you. So I'm thankful for that. Please, you have the floor.
Thank you. Chair Westerfield, Chair Elliott, and members.
Make sure your mic's on, green light.
Here we go.
There you go.
Chair Westerfield, Chair Elliott, and members of the Joint Committee on Judiciary, thank you for the opportunity to testify today. My name is Ali Mock, and I am Government Relations Director for Equifax, with a focus on our Victim Information and Notification Everyday, VINE, service. I'm joined today by Jared Carnahan, who is our Vice President of Government and Victim Services. Equifax acquired Louisville-based Apris Insights on October 1st, 2021, and proudly retained our presence and workforce right here in Kentucky. Our mission is to help government agencies and victim services, law enforcement, and social services make better informed decisions for early responses to people-driven risks. VINE plays a crucial role in Equifax's purpose of helping people live their best lives. VINE stands as a cornerstone mission at Equifax dedicated to empowering individuals and communities through timely and critical information. We help victims and their families become safer and more informed through timely offender release, court case, and protective order notifications. Equifax is not only committed to sustain the success of VINE, but to invest in VINE to expand its reach and enhance the service for victims and everyone affected by crime. VINE was founded in 1994 in response to the murder of a young Louisville woman, Mary Byron. After being incarcerated for raping, assaulting, and stalking Mary, her assailant was released, but she was never informed despite requests from her family to be notified upon his release. On Mary's 21st birthday, her assailant approached her with a gun, fired shots at close range, and killed her instantly. Automation plays a crucial role in VINE's effectiveness, especially against human error, like in Mary's case. VINE has grown to be the nation's leader in victim notification, and we are the largest notification platform with relationships in 46 states. The service is available through phone, text, in-app notifications, and TTY for the hearing impaired, and it is tirelessly supported by live operators 24 hours a day, 7 days a week. VINE additionally connects victims and survivors to local and state resources through a service provider directory. VINE has made a profound contribution to the safety of the victims in Kentucky in partnership with the Justice Cabinet and the Department of Corrections. In 2023 alone, Kentucky VINE facilitated over 679,000 custody and incarceration status notifications, and individuals conducted over 1.2 million searches. Over 208,000 people registered for notifications. The VINE Protective Order, or VPO, delivered nearly 60,000 notifications, further enhancing the safety measures for those impacted citizens. Across the United States, we have delivered more than 800 million notifications, and over 20 million victims of crime and concerned citizens use Vine to stay safe and informed. You are likely aware of the Joint Judiciary Committee in September of 2023. A clear outcome of that hearing was that lawmakers, prosecutors, and victims share a common desire to reestablish robust, automated victim notifications. Currently, Kentucky Vine provides custody and incarceration status notifications along with protective order notifications. However, additional notifications could be provided with the adoption of Vine courts. To that end, after the September hearing, we worked alongside the AOC to find a mutual understanding as to what robust Vine courts would look like from a data, integrity, and implementation perspective, and to do so as cost effectively as possible. My colleague Jared Carnahan will briefly identify some of the stated tension points that prior AOC leadership articulated and how Equifax intends to resolve them.
Good afternoon, Mr. Chairman, and members of the committee. My name is Jared Carnahan, Vice President of Government and Victim Services for Vine. I've lived in Kentucky my entire life, and I'm a constituent of the 36th Senate District and 31st House District in eastern Jefferson County. As a lifelong citizen, I am proud to now lead the Vine team and contribute to a safer Kentucky. It is fundamentally my job and number one priority that Vine works and works well. And I can confirm that the Kentucky Vine system is operating as it's intended. I appreciate the opportunity to stand before you. Equifax continues to invest in technological advancements and operational improvements to better serve victims of crime and concerned citizens. We expanded our offerings to include court notifications, a service we call Vine Courts, and that product was utilized by Kentucky until 2021. In an effort to restore the service, we brought in engineering, legal, and technical expertise and worked to solve requests that were specific to Kentucky's AOC. As you can understand, Vine relies on comprehensive data from the state to provide timely and accurate notifications. Data elements often include case numbers, court dates, event types, courtroom notifications, and defendant identification information. Kentucky's AOC sought a more specific approach for selecting the data elements sent to Vine, and we collaborated to define a suitable method while upholding system integrity. Our second discussion point as it relates to the data is receipt of all court cases and their supporting data elements to be searchable in Vine. Typically, a state transmits all court cases to Vine so that victims and survivors, those in a support role, defendants, and concerned citizens may search for and register against a case to receive timely notification on hearing updates and statuses. The AOC has expressed a preference to forward only those cases they have determined to have an identifiable victim, and we were able to meet that preference. Addressing concerns regarding data privacy and usage, I want to emphatically reiterate that our organization does not retain search history or engage in any unauthorized use of registrant or victim information. The only use of registrant data is in the instance we are legally required to provide it or if it is within the provisions of the Vine service. In closing, we strongly believe that through partnership with the AOC, Kentucky's citizens would have the seamless and complete automated notification system that they expect through Vine. We are grateful for the support of this committee and seek to continue partnership to advance a safer and more informed Commonwealth. We appreciate your time today and would be pleased to take any questions.
Thank you both very much. We do have a question before I call on Representative Nemes. So I wanted to ask, just to clarify, you still have an active agreement with DOC? Is that right?
We do.
What agency is informing or providing data for the EPOs and DVOs? You mentioned that you're having offender data, but you also mentioned the protective order data. Where's that coming from?
I would have to defer to DOC for the specific agency. The contract is with DOC for the support of the
So you don't
service.
have a contract with any other state agency in Kentucky?
We have a master service agreement in Kentucky that allows us to service multiple organizations within the state.
Gotcha.
Yeah.
Are you aware of any other agencies you're serving besides DOC pursuant to that agreement?
Kentucky State Police, Kentucky Labor, and Kentucky CHFS, all with varying services not related to victim notification.
Thank you. Representative Nemes.
Thank you, Mr. Chairman. I want to thank the people at the table and also the people from the court system for coming to testify. Mr. Chairman, I want to thank you in particular for making sure this continued on our radar screen because it doesn't seem like anything has happened. I know there's been some changes, and Ms. Comstock said that some things have developed, but at the end of the day, this is now 3 years the court system has decided to stop notifying our people. It's their responsibility to do it, and they're not doing it. It doesn't. I don't understand this. Why we think going to a manual project is appropriate when while I'm sitting here, I've gotten a couple FedEx notifications. I mean, it's part of the world. I know you guys serve a couple dozen state courts, and again, as the chairman said, we don't care if you get the contract or anybody else. We just want the information provided. How long would it take if you got the data from the AOC today to get this thing up and running?
If we receive data today, we could have the system live within 45 days.
Okay, I'd like to have the same question asked to the AOC, Mr. Chairman. But I'm also frustrated that it's been a year. There was no request for money from the AOC by their court in their court budget request that they just made. We would have funded it. This is something very important to us. I think we made that pretty clear last year. And it also frustrates me when we come and we get, well, the reason we stopped providing the data to APRIS is because, the court says, is because they were misusing the data. Well, I'm pretty sure, as I said last year, the administrative office of the courts can find a judge to get an injunction if you're breaching the contract. This is extremely frustrating that we're now 3 years in and the court is not providing this information that would be rather simple to provide. And it's not very costly. I mean, we said a couple $100,000. There was no request. It'd be easy to make that to make that budget request, to meet that budget request. It wasn't made. I'd like to ask the AOC, when is this going to happen? We got 45 days here. When is the AOC going to start notifying our people? If Katie could come back up and Ms. Comstock could come back up and answer that.
Absolutely. You're part of leadership, so you're part of the budget process. You know how it goes. I would love to say that I have unlimited budget requests when I come to you all and have priorities. I don't. Having previously been LRC staff and previously actually working on the budget office for 8 years, I've seen how all 3 branch budgets go. I've got a limited bandwidth for requests. So for as a branch as a whole, one of the things I've learned really quick with AOC is we do a whole lot, and there's a great bit of need for a unified court system. As you know, you used to be AOC director.
Yeah.
There's a lot of need.
I also know we funded your budget and then some this year.
Correct. But when we come with like requests, you know how it is. I can only come in with a small group. And so for the priorities of the branch, like the big things, we asked for, greatly appreciate, additional mental health courts. That was funded. Maintenance pools, because we have courthouses that have been falling apart. That was funded. You know, having an additional pay increases, which are greatly needed for our people. That was funded. And I cannot thank you all enough for that. So when our top tier request that, you know, is a court branch-wide request, we only have so much bandwidth and so much requests. I'll also say, you know, the budget requests this year were due on October 1st. You know, I testified at the end of September. At that point, budget requests had already gone. And I'll say as a new director, like this was different for me. I'm used to, well, working for you all and being on the other side. So as I shepherd a budget through, still trying to work the process, knowing that there's a limited bandwidth and that you all are super busy and it's hard to get in front of you. So when I'm getting what I got in front of you, which I turned in October 1st, was the branch's true priorities. And I know you say, oh, it's only a couple $100,000, but for our branch, that is a lot. We don't have a lot of extras. You guys will start hearing me talk about, we are in the process of an RFP for a new CMS. This is coming. It is going to, at the end of it, it's going to be phenomenal and it's going to be wonderful if I can survive till we get to the end of this. But there's additional costs that are coming, and this isn't just a one-time fee. You know, it's one thing if it's a one-time, no, this is an ongoing annual appropriation that we would need in order to cover it. And I'm going to need that for some of our bigger ones like the CMS, which is the backbone of the entire judicial system. So I wish we had unlimited resources and I had unlimited ask when I come with the budget, but I don't.
Mr. Chairman, I respect all of that. What I would say is we had a hearing on this issue, and I think it was before the budget request, and I think it was pretty crystal clear that I remember Chairman Westerfield being very respectful but very forceful and what he had to say, and a number of us were as well. So if this wasn't a court priority, it certainly is one of our priorities. It should have been requested. Okay, I know it's not a one-time fee. This could be a one-time opportunity for a woman who's been abused to not get notification or something of that nature, and then something terrible happened. We want this to happen. Let me get to my question. When will it be up and running where our people will be notified?
Well, I will say the prosecutors have the constitutional and statutory duty to do now, and Judge Coron can speak to that much better than I can. So right now, if victims, they can go on our website and they could see when court dates, but also it's the prosecutors, not really the courts.
So the court doesn't have any.
And if I'm going to let you finish that,
Yeah,
Representative
okay.
Williams. But I also wanted to say, and I said this to the APRS team, we had a call a couple weeks ago, whenever the heck that was, guys. And I think Director Comstock, I mentioned this to you too. I don't know that the OAG's been asked. Prosecutors were given a big, enormous appropriation. I think even above, I forget how many millions more, and a big chunk of that was for that RFP, for their own case management system of some kind, the RFP that they've just put out. I don't know when they put that out, but until you said that they'd put it out, I didn't know that they had. And so I don't know if the OAG's even been asked if they confront some of that additional cost. Because I completely agree, as Judge Coron said, the prosecutors are doing this today. Now they've got to rely on court data, so I think AOC's got to be an integral part of that. But I think it's perfectly acceptable to draw from a couple different pots of money. And if one agency doesn't have it all, it's worth bringing in all the agencies that are affected by it to have that conversation.
And Mr. Chairman, they have to rely on court data, and they also have to rely on human beings. This is automated information. Judge Coron said that we shouldn't use everything as a cookie cutter approach. We couldn't agree more. The court system has this information. The clerk enters it. It comes immediately to me as a lawyer. It should go immediately to the victim. So I want to ask again very pointedly. I think your answer was we don't intend to. You didn't say those words, but I think your answer was we don't intend to ever do it. It's the prosecutor's responsibility. So let me ask very quickly, very, very directly. Does the AOC intend to ever directly notify the victims? And if so, when is it going to happen?
Very much from what I testified, since the prosecutors have a CMS right now that is going to have victim notification as a part of it. I think very much so you want us to be good stewards of taxpayer dollars. That is where, and 45 days, they think from their perspective, because I know that was a question you had as well. From our side, it wouldn't be 45 days because we'll have to make changes to our system.
Do you even have the prosecutor's data that you'd need? Because you mentioned earlier, you'd need victim contact information and all that stuff that you don't have today. So that's not something you'd have to get that from the prosecutors. And Judge Coron, I don't want to have you speak on behalf of prosecutors. I don't know that they're all in a place where they can provide that data in a expedient format electronically, all uniformly to AOC, even if we wanted to do it today. Is that something? And I'm speaking way out of the wheelhouse now, because you're not a prosecutor anymore. Do you know if what they're asking to build would allow that?
My understanding of what is trying to be built and the RFP for it is going to, and what Representative Nemus is talking about, everybody wants it automated. And I think that is the best case scenario. But it's got to be under the guise, like we said, of making sure it is done appropriately and not just one size fits all. I know that the RFP for the prosecutors is going to have to coordinate technology-wise with the court system.
I was just whispering, I think we ought to have PAC come in here and help shed light on at least what they're looking to build, what the RFP looks like. Representative Nemus.
The last thing I'll say, Mr. Chairman, until this is resolved, I think it is a poor, I know my friend Mr. Comstock said we have to be good stewards of taxpayer funds. You're darn right we do. But part of that is making sure victims are notified of court proceedings. So I think what we've been doing with the court's recalcitrance is the problem. So, Mr. Chairman, what I would hope to do, and with all great respect, but this is a problem that should have been fixed. It has not been fixed. I don't know how much more we can express our dismay and our I'll just say that word. So what I would suggest is that we bring the court system in here every 2 months to give us an update until this is resolved. There's going to be a situation that something happens very badly, and I want to be very clear that it's not acceptable. It hasn't been acceptable for a long time, and it needs to be resolved. We've got 45 days here. They provide it for dozens of states. We have our victims organizations. They're here. They need information. And I think the court is being recalcitrant in this, and I think it's unfortunate. Thank you, Mr. Chairman.
All right. Want to have Beth come back up briefly, if I can, with DOC. or anybody else from the DOC team that wants to join her. Thank you. No, you're good. Make sure your mic's on. Might pull the mic up closer to you. If the green light.
There you go.
Hey,
Okay.
now it's on.
So as I said before, I'm Beth Moore, Staff Assistant with the Department of Corrections and Legislative Liaison, and I have with me 2 other DOC members.
Hillary Daly, Deputy Commissioner.
Yes, ma'am.
Alexis Williams Hall. I'm the branch manager of our Victim Services branch within the Department of Corrections.
So what do you provide to victims today?
Okay, so I'm going to go over real quickly. I've lined out some of the things you've already heard, so I'll be brief. But historically, VINE had 3 components: offender status, protective order, and court hearing. And it should be noted that VINE is a registration-based system that requires individuals in the communities to register in the system to receive notifications. So VINE offender status is the one area you all have not heard about so far today. It is an automated service that allows users to track the custody of offender over the phone or internet. Equifax Workforce Solutions, formerly known as APRIS, receives data from the Kentucky Offender Management System and from the county jail booking systems to provide notifications to the registrants. The VINE interface with comms transmits data every hour, 24 hours a day. However, for security reasons, that data is on a 2-hour delay. The VINE system tells the user if an offender is in jail or in prison, as well as other important custody information. VINE also allows users to provide a phone number and or email address to be notified automatically when that offender is released, transferred, escapes, or has an upcoming parole hearing. The next component of VINE is protective order. VINE protective order allows users to check the status of the order and provides reminders to upcoming court hearings. It incorporates the Brady Bill notification to make petitioners of an EPO or DVO aware that the respondent has attempted to purchase a firearm. Lastly is VINE Courts, which is what AOC has been testifying about. So that's the 3 components. There is no longer a specific VINE contract. In recent years, this was consolidated. We have consolidated all of APRIS Insight contracts into one master agreement issued by FACOPS. The agreement is now between the Justice and Public Safety Cabinet and APRIS Insights, of which VINE is only one small part. The scope of this includes the administration of VINE and VINE protective order programs for the Department of Corrections. The current agreement expires on June 30th, 2025, and there are 4 one-year renewals remaining. The last thing I would like to discuss, as you all mentioned before, was the recent outages. The VINE system as a whole has only had 1 outage in recent years. On May 5th, 2023, the system alerted to an interruption in VINE. The outage lasted for 10 hours, and by 7 p.m., the backlog of all data was processed and normal operations continued. The more common experienced issue lies between the jail booking systems and VINE. Each jail facility, has an established interface between the booking systems and VINE. APRIS Wide Area Collection System is a device used to connect each jail facility booking system. The data from the jails is transmitted every 15 minutes. The outage issues occur when a jail booking system has an outage or a technical issue. When this occurs, there is no data that can be transmitted to VINE or to comms. However, that does not mean that either of those systems are experiencing issues, just that the jail system is experiencing an issue. The VINE does not receive data from if it does not receive data from a specific location, there is an automatic notification email sent to all staff and all registrants. A second notification is then sent as soon as it is resolved. During the outage time that VINE alerts, alerts are completed through a VINE link website of an emergency override procedure. The Department of Corrections VINE staff has trained all 79 jails in person, and they offer continuous training throughout each subsequent year on this override process. The emergency override process that is used during those downtimes takes under 30 seconds and immediately notifies all victims. And we're happy to answer any questions about our 2 components.
Representative, go ahead.
And this may be for Director Comstock as well. So I'm still trying to wrap my head around some things, and I do have a question. It'll take me a second to get there. We've had a discussion about automatic expungement as well, and there are reasons that can't happen. So is this a bigger problem with the computer? And I'm not techie at all, so I don't even know that I know what I'm asking. Is this a larger problem with the computer system that we can't do all these things that we're supposed to be doing? Do you understand what I'm asking?
Stick right in here. I'm just going to crouch beside you. Sorry. Two totally different issues. When we're talking about like Vine notification and the different, that is a different issue than automatic expungement. The automatic expungement issue is because we have a paper-based criminal record, and one of the reasons
Until we enact clean slate, and then it'll be more automatic.
Well, I will tell you, I would love to. Sorry, since I have.
But we have a system that would support all these different programs. That's what I'm trying to ask. Maybe that I asked it the right way that time.
Well, and again, automatic expungement is a little bit. We don't have an all electronic record on the case on the court side yet, and one of the reasons is we have a whole old homegrown case management system. We have two different versions running in the state right now. It's called KY Courts 2 and KY Courts 3. What we're in an RFP now for the first time ever is to have a vendor solution that all 120 counties can be on. And the reason we couldn't be in all electronic records is because our current case management system can't handle all of those electronic records. So that is separate from this one when we're talking about Vine notification. What we've done before was a data share through DOC's contract to allow for the notifications with their vendor.
Okay, just one follow-up. So our system does support this for Vine, so it can work.
For the victim notification
yes.
on the court side, if we were to pay those additional money and to do that, it could potentially work. But again, the prosecutors, if you're looking for the prosecutors are already building their own system. And I think there's been a lot of conversations about like the court's responsibilities, but if you look at like Marcy's Law and the Constitution and what the court's responsibilities are, it's in another lane once they actually get into court.
Thank you.
You're welcome.
I just want to.
Sorry.
Thank you, Director Comstock, for stepping up. I just want to highlight something, and maybe because I definitely want to have Pat come in here and tell us what the status of their system is and what it looks like, and learn more about it. But we've got PAC that's working on an RFP, or that already has one out there for a case management system platform. DPA is doing that. AOC is doing that. Seems like this would be a really good time for you all to make sure that they talk. Because if you end up with 3 different groups, 3 different companies providing the services, then some poor judiciary chair from the Senate after I'm gone is going to have to deal with some other headache down the road. So I'm asking, just me, y'all should probably have a conversation amongst yourselves to make sure you're all singing from the same tune, to make sure at least that the data is interoperable between those platforms. Yes, ma'am. Thank you, Representative Herron.
So sorry, I keep
Senator-elect Herron.
Couldn't agree more. We've had in the past with DPA's old case management system a data share agreement. It's very much similar to what we have with many justice partners, what we'd want to have with PAC, but also what we have with KSP and lots of other that we do with governmental entities, these data
It'd solve a
shares.
lot of problems if everybody was singing from the same.
Oh, yeah, and DOC, like we have lots of people.
We really want to share with them, too.
Yeah, so.
All right. Thank you all. Last question on this group, Representative Dome.
Katie, you'll probably want to come back for this one too. So, yeah.
Until the next batch of DOC folks, which isn't y'all.
So I filed a case 2 weeks ago. It was the 1300th thereabout case filed in Kenton County. As part of that, I think there was a $25 court filing fee for court maintenance. Funding seems to be an issue with this. What discretion do you have? Does it take a legislative action to allow the courts to increase filing fees in order to pay for something like this?
Well, we actually have language in our budget that's been there the last couple of years is over a certain amount, if we increase filing fees, they're swept to the general fund. So, and I know the reason when I used to be on the budget why that is. I understand, but that is one of the things when people have asked, why don't you just increase fees?
Because I don't know why that is.
Yeah.
I don't feel right doing that because when I used to be in the budget office, I will just say historically that came about. And so we can't just increase filing fees because, I mean, we could, but then it would go to the general fund.
So if the legislature would allow the court filing fees to go to fund the courts that we're constitutionally required to fund, we would be able to resolve that problem.
You mean for the 25? There's many things. We can have a very large conversation I'd love to have with you sometime. As you guys can probably tell with my budget background, I get geeky when it comes to budget stuff.
My question was rhetorical.
Oh. Can you tell I'm flustered? Thank you.
All right. Thank you all. I appreciate it. Director, I appreciate it. Ms. Mock, thank you. And the APRS team. Jared, I appreciate it. Beth and the DOC team, thank you. I do think we need to hear from PAC just to learn about their system. So hopefully later on in the interim, we'll have some time for them to come in. Our last item on the agenda is DOC again, but again, a different group. Earlier this year, just in the last few weeks, the Federal Prison Oversight Act was enacted by Congress, and I got to thinking, because there are tons of horror stories about facilities, federal prison facilities, and I was curious and wanted to get a report on Kentucky's prison facilities, just from a physical plant and safety and health standpoint. Once upon a time, a few short years ago, the legislature used to enable the interim committees to travel for a couple of meetings each interim, and so this committee has had its meetings in a handful of different prison facilities around the state, but it's been a decade, or the better part of one. So I don't know if I have Mr. Jordan or Mr. Watt. Thank you, Mr. Watt. I appreciate it. Tell us what you can tell us about DOC's facilities around the state. You hit your mic there, but make sure the green light's on.
Oh, no, it's not.
There you go.
Good afternoon, Mr. Chairman, the rest of the committee. Thank you for the opportunity to speak today. I'd like to give a brief overview of the current facilities that we have in the Department of Corrections, and I have a script actually written up. The Department of Corrections oversees 14 state prisons, which encompass 629 physical structures spanning across approximately 8,600 acres in 10 different counties within the Commonwealth, 12 of which are owned and operated by the Commonwealth. During the 2023-2024 capital planning process, it was determined that establishing an institutional physical plant mapping system would be beneficial for the 12 state prisons to establish an age, condition, and needs-based assessment of critical prison infrastructure components. The system is up and running, and it is called Archibus. Archibus has been implemented at the institutional level to automate the preventive maintenance system, decrease energy maintenance cost, as well as extend the life of the equipment over the infrastructure. Along with this data has provided mapping for a more predictable estimate of needed capital funding in the future. During the FY 22-24 biennium, DOC received a significant increase in capital funding, as I will go over to kind of give a brief history from 2018. From 2016 to 2018, we received $16 million, $5 million for maintenance pools, $11 million for other line items. For 2018 and 2020, $9 million, $6 million for the maintenance pools, $3 million in other line items. 2020, 2022, $36 million total, $10 million in the maintenance pools, $8 million in the design of the Little Sandy expansion, and $18 million in other line items.
Let me stop you real quick.
Yes, sir.
Sorry to mess up your script
No,
there.
you're fine.
Do you happen to know whether or not, and by how much, what you received differed from what you requested in each of those budget cycles?
It's usually a large disparaging. We had actually submitted $20 million for each year for the maintenance pool, so we'd been requesting $40 million over the past. So that decreases on the average of $5 million for the previous years for all those, dating back to 2013.
Thank you.
Yep. Moving on to 22-24, $326 million, $171 million in the medical services expansion, $106 million in the Little Sandy expansion, and $44 million in the maintenance pool, and $5 million in other line items. For 24-26, $334 million, $165 million for two large projects at the Eastern Kentucky Correctional Complex, $29 million to design a new prison, $58 million more for relocating medical services, $40 million for the maintenance pools, and $42 million in other line items. As a result of the generous, timely, and vital increases in the capital funding projects, DOC was able to commission two projects which employ expert consultants to review age, condition, rank by priority, and suggest estimated cost of vital infrastructure repairs. These two projects were divided directly into the MEP studies and roofing assessments. Using funds from the 22-24 maintenance pool, the department undertook a statewide in-depth study which was completed in May 2024, the study identified 455 items that are in need of a repair, replacement, or upgrades, categorized by the mechanical, which is HVAC, electrical, and plumbing, further breaking these items into categories outlining estimated repair, replacement, upgrade cost, and prioritizing the repair sequence based on immediate repairs needed within the first year, 3 years, then the next 5 years. Another effort that began in 22-24 biennium was the statewide in-depth assessment of the roofing systems. This analysis was completed in December 2023. The study identified 64 roofs that needed replacement. It was recommended that the roofs be reassessed every 2 years for additional replacements, as many of these roofs have surpassed their life expectancy. As far as our major construction projects, the Kentucky State Reformatory Correctional Medical Facility replacement, current spending on that project is $256 million total. The construction of a 373-bed facility is currently at 40%, with all foundations complete. 40% of the structures are currently under roof. The substantial completion date is now scheduled for March 2026.
Where was that?
That is the medical expansion move from the State Reformatory to the Blackburn area.
That's $250 million?
Yes, sir.
Okie dokie.
It is a complete medical facility. The Little Sandy Correctional Complex Phase B expansion, $111 million. The construction of the 2 dormitories totaling 832 beds is currently at 55%, with both buildings currently under roof, plumbing and electrical installations at 60%. Substantial completion date is currently scheduled for March 2025. As previously discussed in the Strategic Planning and Facilities document presented by Deputy Commissioner White back in 2023, the increased allotments for the maintenance pools have allowed us to correct our previously identified major and minor needed repairs as outlined in our 6-year capital planning document, including major food service kitchen drain issues at 4 facilities, various HV and roofing projects, and other issues located at our physical plant. Also additionally funding our MEP and roofing studies as previously discussed. As far as funding updates from our appropriated capital projects, from our maintenance pool 2022 and 2024, we were awarded $44 million. That funded 85 projects across the Department of Corrections, encompassing the MEP and roofing projects. That current balance sets at $40,000. For maintenance pool 2025, $20 million was received. Funding is already allocated for 8 projects encompassing those same MEP and roofing projects. The estimated balance as of today is $6 million. Various water tower repairs, $4.2 million. These are funding the water tower repairs at the Kentucky State Penitentiary, as well as the Eastern Kentucky Correctional Complex. This was made possible by the additional allotment of $2.1 million to complete both of these projects. The Kentucky State Penitentiary Security Fence Addition totaling $3.6 million. Making this project possible was the additional allotment of the $2.1 to provide safety and security of that institution. The below projects are due to be started or actually in the works of starting with the newly appropriated funds. We have a Repair North Point Training Center, exterior dorms masonry tuck point at $2.3 million. Renovate North Point Training Center restricted housing unit at $1.8 million. The Eastern Kentucky Correctional Complex facade structure repair and replacement at $85 million. Upgrade Green River Correctional Complex full electrical system, $4 million. The Eastern Kentucky Correctional Complex HVAC replacement, $80 million.
Let me interrupt you.
Yes, sir.
Are all the prison facilities HVAC systems currently functional?
They are currently functional. There are hiccups that go along with those. We do have some rental items at each of these facilities to maintain HVAC according to ACA standards.
What is that? What is a rental item?
They're actually rental chillers. They're trailer mounted or rental cooling towers. They pull up, they run hoses or ductwork.
How many facilities are relying on such devices today?
Currently right now 2. And it's only 1 dormitory at each one.
Okay.
We're currently troubleshooting an issue at Eastern Kentucky Correctional Complex with a cooling water loop that has a substantial leak. And hopefully we will have that back 100% online. It is functioning, but we're using a lot of makeup water to maintain temperature at that facility.
Are there any pending cases, claims, any litigation or complaints against the department because of the facility or the condition of any of the facilities?
I can't speak to those, Mr. Chairman. I'm actually just the facilities director. I have no idea.
So you're just not aware of any?
No, Mr. Chairman.
Okay. Continue.
Next one is the design level 4 prison in Eastern Kentucky. That's at $29 million. And lastly is the replace the Kentucky State Penitentiary utilities infrastructure at $4.3 million.
Very quickly, would you please provide a copy of your testimony to the committee?
Will do.
Thank you. And is that, did you say arquebus?
Arquebus.
Is that something that is publicly accessible, or is that an internal instrument? Or
It's an internal instrument. Actually, there's a login. It is all the facilities can kind of see each other. There is a management tool that outside commodities that can go into and actually look up data. It provides data as far as the equipment.
does it allow reports output?
Yes, Mr. Chairman, it does.
Well, I kind of want to. I'd love to just tinker around in there and see what the facilities look like and get more information. So I'm not sure what report I should ask for. I'm curious about the average age of the facilities. I'm curious about. You mentioned roofs. I've already asked about HVAC. Lots of questions there.
Mr. Chairman, I can run down kind of the ages of the facility if you'd like.
Can you provide that in writing?
Sure.
Just
Absolutely.
in the interest of time.
It is in the previous Department of Corrections strategic planning document.
Can you also, if that's true, send that if you don't mind?
Yes, Mr. Chairman.
And would it be possible to get, I don't know if capital planning would have it, or if you could more easily provide your capital planning submissions or project submissions to the committee, that'd be helpful. I'm not trying to step on capital planning shoes, but no sense in redoing the work. If you've already got a report, something that's got concise information that spells a lot of this out that we can look at, just forward that to us.
Yes, Mr. Chairman.
All right. Any questions? All right. Seeing none. Thank you, Mr. Watt. I appreciate it.
Thank everyone for their time.
Members, next committee meeting is Friday, August 23rd at 11 a.m. We'll see you then. That's a state fair switcheroo, if I'm not mistaken.